Good afternoon, Madam Deputy Registrar. Would you please open the proceedings?
Thank you, President. Good afternoon, Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, delivery of reserved judgment in CCJ Appeal BZCV number 2 of 2025 between Erven, Marin and others and Belize Telemedia Limited. The members of the delivery panel are Mr. Justice Anderson, President and Presiding Judge.
Good afternoon, everyone.
Madam Justice Rajnath Lee.
Good day, everyone.
And Mr. Justice Jamadar.
Good afternoon to everyone.
May we have the appearances, please? Thank you.
May it please the court, Priscilla Banner, SC, appearing on behalf of the appellants, along with Alison Courtney. We are also holding brief for Mr. Eamon Courtney, Senior Counsel, who is not present and who offers his apologies to the court.
Thank you.
The respondents, it is Learned Senior Counsel, Mr. Fred Lumore, appearing along with Learned Senior Counsel, Melissa Balderrama Smaller.
Good afternoon.
Good afternoon, sir, and thank you very much. We have a decision in this matter for you. It's a unanimous decision by all 5 members of the bench. Unfortunately, 2 members are not with us on this occasion. Justices Barrow and Ibo Osuji, but they both concur in the judgment. There were 2 authors of the judgment, Justices Ibo Osuji and Jamadar, and I'll ask my brother Justice Jamadar to deliver the judgment. Judge?
Yeah, thank you very much, President, and good afternoon to everyone again. First of all, this summary is not to be taken or treated as authoritative. It is a summary, and the only authoritative source is the substantive judgment, which will be put up on the court's website in due course and later today. This is an appeal from the Court of Appeal of Belize in the case of 10 former employees of Belize Telemedia Limited, BTL, who claimed entitlement to severance payments under the Belize Labor Act, the Labor Act. There are 2 main ways in which the Labor Act is of interest in this appeal. The first is that Section 183 of the Labor Act entitles an employee who retires after 60 years of age to certain minimum severance benefits, as long as that employee worked for a continuous period of 10 years. But an employee who is younger than 10 years will still be entitled to that severance payment if the employer terminated that employee before age 60. Notably, retirement by the employee and termination by the employer are not the only ways that the Act imposes an obligation to pay terminal benefits to an employee who is less than 60 years. An employee who simply resigns is entitled to gratuity, that is, equivalent to severance pay. The second main way in which the Labor Act is of interest to this case is that Section 194 requires employers to ensure that severance payments that accrue to employees are accounted for in any pension plan that may be in place in the workplace. The appellants in this case had either compulsory retired at age 55, pursuant to the collective bargaining agreement, CBA, between the BTL and its employees union, or voluntarily retired under individual voluntary retirement agreements with BTL. All the appellants had served BTL for over 10 years. Following the amendment of the Labor Act in or about 1995, BTL transitioned from the regime of severance payments to a pension plan, on the hypothesis that the pension plan had legally displaced BTL's statutory severance obligations. As part of that transition, all employees, including the appellants in this matter, were paid the statutory severance up to 1994. Thus, clearing the way for the pension plan as the only terminal benefits scheme that BTL recognized for its employees. The appellant's claim is that the pension payments they received either did not account for the severance pay mandated by the Labor Act, or that BTL has not shown that to be so. First instance, the High Court ruled in favor of all claimants, including the third group of resigners, finding that they were all entitled to severance or gratuity equivalent to severance pay. The trial judge held that mandatory retirement under the CBA amounted to termination by the employer, and that the voluntary retirement was effectively a resignation, both of which qualified for severance under Section 183 of the Labor Act, as noted earlier. The trial judge also found that BTL had failed to prove that severance was accounted for in the pension benefits under Section 194 of the Labor Act, and declared that a clause in the voluntary retirement agreements purporting to waive severance as void under Section 190 of the Labor Act, which has that effect. The Court of Appeal partially overturned the High Court's decision. It upheld the claims of the resigners, but not those of the mandatory and voluntary retirees. The appellate court reasoned that retirement under the CBA or individual voluntary retirement agreements were not termination by the employer, but rather a bilateral agreement, and thus did not trigger severance entitlements under Section 183. It also held that the voluntary retirees did not qualify under the resignation provision of Section 183(2), and instead of nullifying the retirement agreements, it severed the clause that purported to waive severance. On appeal to this court, the central issues were whether the appellant's retirements constituted termination by the employer under Section 183 of the Labor Act, and if the answer is yes, whether the appellants are still entitled to severance pay under Section 183, notwithstanding that the appellants received payments under the BTL pension plan. In the court's lead judgment, Justice Iboye Osuji adopted the purposive approach to the interpretation of the Labor Act. According to that approach, he considered that the general aim of the system of severance entitlement is not to punish employers or employees for severing their employment relationship. It is rather to cushion the employee from the shock of being put out to the pasture of life without remunerative work after years, particularly 10 years or more, of continuous paid employment and without the financial security enjoyed up to then. Hence, for purposes of severance payment under the Labor Act, mandatory retirement under the CBA effectively amounts to termination by the employer, which the employee accepted, and voluntary retirement was functionally equivalent to resignation. Therefore, both groups were entitled to severance under Section 183. Justice Iboye Osuji also examined Section 194 of the Labor Act, which preserves an employee's entitlement to severance even where a pension scheme exists, provided that the severance was not accounted for in the pension benefits. He considered the concession by BTL's counsel that severance had not been subsumed within the pension benefits. Beyond that concession, Justice Iboye Osuji found in substance that BTL's pension scheme, a defined contribution plan with equal contributions from employer and employee, did not clearly account for severance. BTL's failure to demonstrate that the severance payment was clearly compromised within the pension payments meant that BTL's statutory obligation remained undischarged. Utilizing the social justice interpretation framework espoused by this court in the CJI Consumers case, 2025 CCJ 11 AJBB, Justice Jamada asserted that the Belize Labor Act is social justice legislation. Referencing 1, the Belize Constitution, the preamble affirms principles of social justice and prohibits the exploitation of labor, and Section 15 protects the right to work. And 2, Belize's ratification of international commitments that demonstrates a commitment to protecting workers' rights. Thus, Justice Jamada found that the severance pay provisions were not merely transactional, part of a remedial and protective constitutional scheme. Applying a purposive, teleological, generous, and pragmatic approach in interpreting Section 183 of the Labor Act, taken within its social context, he concluded that both the retirees and the voluntary retirees, who are the appellants, all fell within the categories of employees entitled to severance. Furthermore, Justice Jamada applied Section 190 of the Labor Act and opined that it invalidates any agreement that purports to exclude statutory severance entitlements. This applied both to the CBAs and the voluntary retirement agreements. In conclusion, this court unanimously allowed the appeal, holding that all the appellants were entitled to severance payments under Section 183 of the Labor Act, ordering that the severance payments be calculated according to the High Court's judgment and awarded costs to the appellants. President, that is the summary, and I believe you will make the appropriate comment on the amended costs order.
Yes, thank you, Judge. So as foreshadowed, I gather that the parties have agreed on an amendment to the cost order affecting the award of costs in the High Court and the Court of Appeal. Is that the case?
Yes, Your Honor.
Yes,
Thank
Your
you,
Honor.
Mr. Lamar. Thank you. So we have reflected the agreed changes, both in the order of the court and in the judgment of the court. And that will be evident once you get the copies of both. Anything further, Counsel?
Nothing from the end of the respondents.
Thank you, sir.
Much obliged, Your Honor. Nothing further for the appellants.
Thank you, ma'am. Thank you. In that case, Madam Deputy Registrar, would you please close the proceedings?
Thank you, President Anderson. Thank you, Madam Justice Rochnothley. Thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.